as it normally is.
Oh, really?
It's the side showing. It's not a big deal.
It's got the side showing.
Yeah.
Is that better?
A little bit.
Not really.
It's about the same.
Well, I'm gonna need to play with the tech. As always, it's an ever-changing issue that we have. So hello, Julie. How are you today?
Good. How are you, Billy?
Good, good. How's your week been?
My week's been great. January was kind of like, let's crawl in a cave and not come out. And now it's like, yay, let's come out of the cave. So yeah, it's been fun. Things have really been moving. And I think that it's not just like work-wise, but I think there's a lot of stuff going on with relationships too. So I think that there's been an uptick just for people inquiring about divorce, custody, or even post-decree issues too. There just seems to be a reevaluation of relationships and where people stand.
I totally agree with you. Yesterday we had 5 new clients sign up, which is a lot for one day. Like it's a lot. So I totally agree with you. January and February really brings a lot to people when they're reevaluating their relationships, whether they need to modify or their marriage is over and they need to divorce. How have classes been at Win Without Law School?
Yeah, so we have been in classes for about a month now. And each day we focus on a different area of family law. So Mondays, we talk about divorce, Tuesdays, custody establishment, and Wednesdays, post-decree modification. And then Thursdays, we do our trial skills. So we're right now, we talked about case strategy, and now we're talking about case initiation. So petitions, service of process, responding, and then default as it applies. And the process is completely different for pre-decree and post-decree. So when you're establishing custody or getting divorced, there's one procedure. But then when you're post-divorce or post-custody establishment, there's a whole different procedure. So we covered those 2 different procedures in different classes today. And then we do live Q&A after, and it's about anything, really. It doesn't have to be what we talked about.
Sure.
But yeah, it's been going really well. And the feedback has been great. People are just so appreciative to have this type of resource.
Yeah, absolutely. I agree. I've talked to some participants and they're really, really appreciative of learning things they didn't even know they needed to learn and just feeling like they understand everything so much more. So amazing job on that.
Thank you. Yeah, you too.
Thank you.
We've been building this together and it's just been flowing really well. And yeah, the amount of resources that we have continues to grow. And then of course, we're open to feedback to see, if there's anything that people need that we aren't providing. But there's nothing out there like this. Yesterday afternoon, I was the attorney guest at Yavapai County's Divorce 101 class. And it's a good class, but it gives you a lot of information just about how the court works. They're like, oh, this is our court administrator and his office is down the hall, and this is our clerk of court and this is what she does. And there was some more pointed information about divorce, but the court can only give you so much information. And so and it was all about just getting started too. It's just about, okay, how do you start and how does that go? So if you're looking for free resources from the county, like they're doing the best they can, but it's a bit piecemeal. It's not from a lawyer's point of view, most definitely. Mm-hmm. And it's not necessarily start to finish.
Mm-hmm. Absolutely. Yeah. People are doing the best they can to get information out, but I do believe that Win Without Law School is the absolute best resource. Our January special is done, but people can still join now for $150 a month or $450 for a year. And you can do that at winwithoutlawschool.com. Now, in terms of today, Julie and I do a live stream every single Thursday to talk about a family law issue and then answer your questions. If you've got questions, you can leave them in the comments either on TikTok Live or on our Facebook group at Decode Your Divorce support group. So you can join there, or you can leave your questions here, and we will get to those questions after we go over our topic du jour. And the topic du jour is custody mistakes, which is a great topic for us. But first, Julie, can you go over the general disclaimers?
Right. So we are just answering questions on a basic level here. So this is legal information only. We aren't providing any sort of legal advice. We're not in a position to do that. We'd have to meet with you one-on-one, possibly review papers, really get in depth on your situation. So this is just legal information in general. By watching this live stream or by asking a question, neither Billy or I become your lawyer. We're just here to help with legal information. And this is based on Arizona law. We're both licensed in Arizona, so the information we're providing is about Arizona family law.
Fantastic. I'm going to turn you up because I don't have great audio from you. So
Okay.
we're going to turn you up.
A little closer too.
Okay, so Julie, what would you say are the top mistakes that people make in custody cases?
So I've been thinking about this as we were preparing for today, and I think some of it is more big picture. I think that one big mistake that people make is possibly going too fast. Some people rush into a parenting agreement without really giving it some time to see how it's going, because they're like, oh, we reached an agreement. Okay, let's just get this done. But it's not necessarily the best situation. And especially if you're in that tender place where you've just separated and this is like this new experiment that you're in, new things can unfold and you can discover something about your co-parent you didn't know. And sometimes it's prudent to slow down a little bit and walk through the parenting plan for a couple of months before you make a final agreement.
I think that's a wonderful tip. I think there's a lot of desire to lock something down so that everybody knows what to expect, which I totally understand, or lock it down so that you can feel like you're done. But in trying things out, whether it be for a modification or for that initial custody exchange, you're going to learn a lot more and you're going to be able to develop a better parenting plan. Could not agree more. What are some other mistakes that you see?
So I think another big mistake is not looking at the big picture. There's so much drama that can unfold in a custody case. And sometimes you can just get so caught up in that you're not actually resolving the big issues. You're not making any progress on decision-making, parenting time, child support. You're just in this, drama triangle between you and possibly your kids as well, which is a place you don't want to get to. So I think a really big mistake is getting caught in the drama and the anger instead of focusing on creating this new co-parenting relationship.
Yes, absolutely. And I don't know, there's definitely a transition between being a married couple or a couple that is living together and in a romantic relationship to being a co-parenting relationship. It definitely takes time and is a rough transition. I've got a video on our YouTube that has more views than anything else, and it's about how people can lose custody. So it's a little different, but it's really along the same lines. And in that, I say that you will lose custody if you don't understand the system that you're in, if you refuse to accept the things that the system is telling you because of pride or whatever, or if you cannot meet the demands of the family court system. And if I can just explain that, because it sounds so, I guess, like big, huge picture, but in Arizona, it is very difficult to lose custody. It is very difficult to lose parenting time or to lose decision-making. And if you're in a normal range parent, a normal range, so, it doesn't matter if you're the best or you're mediocre. If you're normal ranged, you will not lose probably parenting time or custody if you understand what the court wants from you. And those are kind of basic. And in any given case, you'll know exactly what that is. We'll be able to look at a case that's a big, huge mess, and we'll be able to tell from the judge's order exactly what the judge wants parent A to do. And in that case, parent A can either do what the court is asking, or parent A can continue to focus on parent B's behavior while parent A is in the hole. Does that make sense?
Mhm. Yeah, I mean, there's only so much that's in your control. And so it's often best to start figuring out how you want to show up as a co-parent in this new dynamic versus just, being upset with the other person or criticizing them. This co-parenting thing is, it happens over many years. It's a long-term relationship, which is so different, because if you think about other relationships in your life where you've broken up, it's like, okay, sayonara, I'm going to lead my life now, you're going to lead yours. But when you have a kid in common, it's not like that. Like, now you aren't together anymore, but you don't get to just disappear. You now still have to deal with this person and figure out how to raise one or more children together over the next 10 plus years, depending on, what age your kids are. And it kind of sucks sometimes, because it is nice to just have a clean break and go your separate ways, but that's not really co-parenting, at least initially. Now, that's kind of what the courts want people to do is, okay, break up, get your parenting plan in place, and now you each just kind of have your own separate lives and you overlap with your kid here and there. And eventually they want you to get there, but it can be a bit of a rocky road getting to that place.
Definitely. Yeah. And so also let's talk for a minute about, well, I do want to stick on the topic. The topic is mistakes that people make. And it's hard to even know, we talked about, big picture versus little picture, how much information you should be giving the court, what point you're trying to make. And then I was talking about, like, if you're in the hole, the only thing you can do, and what I mean by the hole is if the heat is on you, if the court is asking you to do certain things, if the court appointed advisor is concerned with you about X, Y, and Z, they want you to change your parenting style, you can, in my opinion, you can absolutely win, but only if you first do what you need to do to kind of check off the boxes and do what the court appointed advisor or the judge needs to see from you before you can even start talking about the other party. That can be incredibly challenging for people to do. It can be incredibly challenging to feel like all the pressure's on them while the other parent is screwing up left and right and nobody seems to care. What can you say to those people?
Yeah, and I'll tell you, this dynamic comes up in all sorts of different types of cases. And it's this position where, are you playing offense or defense?
Yes.
And essentially what Billy's saying is that before you're in a position to play offense, sometimes you have to play some defense first.
Right.
And so if you are getting all sorts of mud thrown at you, you need to address that mud and clean it up before you can start throwing mud at the other side. Because if you just start throwing mud before you've cleared yours, then it looks like you're deflecting. It looks like you're trying to hide something. And then the court could feel like you're ignoring the court, you're being defiant, and then you just sound like someone who's complaining. And so it's this fine balance of clearing your name, showing who you are as a parent, and then exposing the other side. But when you get to that part of exposing the other side, you need to be really selective, because all of the little things that you think are so important, the court probably thinks one or two of them are, if that.
Right. And I think it's easier when you have a lawyer, because you can let the lawyer do the mudslinging and you can just really focus on, you and your attributes and all the things you're doing right. And because courts don't want to see one parent slam another parent. But if you are representing yourself, you have to play both roles. You have to play the role of the lawyer and the role of the parent. Any tips for how self-representing litigants can do that well?
It's all about preparation. And, every self-represented party, of course, that's a broad statement, but they think you have to go to trial and you don't. So the trial is kind of like the last resort. You want to try to resolve this in the meantime, but if you are going to trial, then you need to prepare. And when I say prepare, it's about organizing your case presentation.
Mhm.
What are the 3 to 5 points that you really want to prove to the judge? And then make sure you prove those, organize your case around that, make sure that stuff comes in. But oftentimes people representing themselves just go in and wing it. And then
Yeah.
there isn't really a clear presentation. They don't know how to ask questions, and they get really frustrated, and the judge doesn't have any good evidence to base the decision on. And this is something that people don't really understand, is that the judge has to make his or her decision based on what's presented. And
Mhm.
so it's up to the parties to present the evidence to the judge, because the judge can't just make stuff up and speculate. And so if one side is doing a really good job of presenting the facts from their point of view and the other side's failing, the judge really only has one set of facts to adopt because it's all that's been presented.
Mhm. Yeah, it's a great point.
People think the judges can just are all knowing and they're just going to know the best thing to do. But you have to educate them and explain to them what the best thing is from your point of view. And hopefully you're persuasive enough. But a lot of people just think, oh, the judge is just going to know what to do. But it doesn't work that way.
Definitely not. Definitely not. Managing the amount of emotion to include when you are presenting a custody case, I think, is also a difficult thing. What would you advise for people? How do they manage how much emotion they're allowed or not allowed to display?
So I usually look at emotion in terms of the best interest of the child standards. So I think it's around 11 different standards that the court has to analyze in every custody case. And if you look at those and you start creating the testimony you want to present for each of those points that is relevant in your case, you can weave in your emotional points in a very effective way. So the very first part of the best interest standards is the past, present, and potential future relationship between the parent and the child.
Mhm.
This is your opportunity to explain your relationship with your child in the past, in the present, in the future. So if you are being, if the other side is saying you're a bad parent, you were never around, the child doesn't know you, this is your chance to rebut that evidence by explaining, no, I was there when this child was born. And I remember, and this is maybe when you show emotion and you start crying and you're like, gosh, I remember when my daughter, Carolyn, was born. And I remember holding her for the first time and then caring for her. And then I remember when she took her first step and teaching her to read, or, whatever those special memories are. But you can then, with a really heartfelt story right there where you get emotional, the judge is like, wow, this person knows their child. You don't have these personal stories and this amount of emotion if you are disconnected from your child. So you can rebut some of these allegations just by utilizing the best interest standards. Another one of the standards is number 6, and it talks about which parent is most likely to allow frequent, meaningful, and continuing contact between the other parent and the child. So if you're a parent that's been denied contact with your child, this is your opportunity to explain what happened, to show your emotion, to explain how you felt when you were denied time with your child. On the flip side, if you're the parent that denied the time, this is your chance to explain why you did it and why it was justified.
Mhm.
So really looking at what's at issue, which are these best interest standards, and then weaving in the facts and emotion of your case can give you a really solid presentation instead of you just going up there and willy-nilly making accusations against your co-parent.
Absolutely. And the other thing that these best interest factors do is they redirect. Our natural inclination might be to talk about what a jerk the other party is. But if you filter all of your evidence and your evidence presentation and your organized talking points through the factors, it forces you to focus on what the judge wants to hear about, which is your child, not your ex, because you guys are done. It doesn't matter from the court's perspective how awful or toxic your relationship was, which is very controversial because domestic violence is supposed to matter, but they view that as over. Your relationship is over. Now it really needs to be about your child. So if you're trying to prove that the other spouse is dangerous to your child, you are better off coming up with examples of what happened between the two of them as opposed to between the two of you.
Yeah. Or that the child was present when something happened between the two of you, either verbal or physical abuse in front of the child. The judges take that very seriously. They don't want the child to be exposed to domestic violence.
Yeah. And also in that case, I think if you can show instances of other violent behavior with other people, that will even strengthen your argument, because some judges will say, well, the child's not likely to be exposed to domestic violence because the parents are breaking up. But if you can show that there's a pattern of domestic abuse within multiple relationships, then that child is not safe from witnessing that in the future.
Yeah, it's such a great point that it's important to frame your case around the child.
Mm-hmm.
And so anytime you're thinking of evidence about your co-parent, think of it, okay, how can I put this in terms of the child?
Mm-hmm.
So, I want to show that my co-parent can't control his or her anger.
Mm-hmm.
Okay, well, let's not think of a story where they couldn't control their anger just with you.
Right.
What's the story where they couldn't control their anger with the child?
Exactly. So much more effective to lay out, that your child was trying to eat pizza and wouldn't do it, and the parent blew up and threw the pizza.
Yeah.
Might even be a more effective story than the time that your co-parent broke your phone, even though, you should probably include that too, but if you can frame everything through how this impacts your child moving forward, and therefore why your parenting plan is important, if you can tie these things together, and this is why I'm asking you to do X, Y, and Z, it's just a more effective presentation.
Yeah, the judge doesn't want to just hear complaints.
Mm-hmm.
The judge is going to want to hear, how is this evidence tied to the child? And then what do you want the judge to do about it?
Exactly. Because we talked about how hard it is to lose custody, to lose parenting time. There is a enormous cultural preference in the state of Arizona for parents to spend time with their children. And some people disagree with that. They think that a child would be better off without a, mean or dangerous or toxic parent in their life. But that's not the system you're in. The system you're in values a relationship between parent and child above almost all else. You must prove it's dangerous, not just like detrimental, not just potentially bad, but like actually dangerous, which is a very high standard.
Yeah, in my experience, the courts favor the child knowing a parent, even if that parent's horrible, versus them not knowing the parent.
Mm-hmm.
And so even if you prove dangerousness, the court can still be like, okay, well, then we'll do supervised and we won't do overnights. And like the court will likely still order some amount of parenting time. It just may be restricted. And the other thing that can be really frustrating about the family law courts is that they're reactive. You can come in with all sorts of speculation, be like, I know he's going to abuse the child, or she's going to drive drunk with the child, or whatever you believe is going to happen. The court is not going to issue orders based on speculation. The court is going to wait until that worst case scenario unfolds and then make an order to address it. And it's frustrating as a parent. You're like, oh, I knew she was an alcoholic and I told you she was going to do that. Right. But from the court's perspective, there's, due process, there's this issue of speculation. You can't just, based on what one other party is saying may happen, curtail a parent's parenting time based on that. We generally have to wait until the bad stuff unfolds, and then the court will punish based on what happened.
Mhm.
And it sucks because the child or, the children can be put at risk in the meantime. It's a very frustrating situation if you're dealing with a volatile parent. But unfortunately, that is how the courts work. I mean, fortunately and unfortunately, depending on
Right,
your point of view and the
right,
situation.
right.
But you can't just come in with speculation and think that you're going to get a very restrictive parenting plan.
No, but if you have evidence of past DUIs, if you have evidence of alcoholism, you don't have to wait until your child is hurt. So the conversation is so hard because some people whose children are currently in dangerous situations will agree to equal parenting time because they're hearing from us that it's very hard to limit parenting time. And depending on you and your specific situation, you should not agree to equal parenting time. If you have evidence of DUIs, evidence of car accidents, evidence that this person is going to be dangerous to your child, don't agree to equal parenting time. Ask for SoberLink, ask for alcohol monitoring. Find ways to keep your child safe while still providing a way to get them time with their parent, if you can do it.
Yeah, definitely. There are so many new options right now with the SoberLink, and with different communication apps, that there's different options out there than there used to be. And one side point on supervised parenting time, I can't remember if we talked about this or not, but a lot of people go, oh, I want supervised parenting time, and just think that that's it, and the court is somehow going to address that request. But it's not that straightforward. If you're going to request supervised parenting time, then you need to have a very detailed proposal. Who's going to be the supervisor? If it's a private company, who's going to pay for it? It's very expensive.
Mm-hmm.
And then if it's not somebody who's being paid and it's a family member or a friend, it's you as the co-parent, you need to lay out the terms, and it's not as easy and straightforward as it sounds. Nobody really wants to sit and look over someone's shoulder while they're parenting.
Yeah, and for how long? Because that's not a permanent solution. It's just not. So really thinking practically about what can I offer. And that's where talking to a family law attorney can be really helpful, because we've seen a lot of parenting plans. We've seen a lot of ways that courts will do X, Y, or Z. And so we can usually make some suggestions about what may have worked or not worked in the past.
Yeah, and I think the third biggest pitfall for custody cases is not having a detailed enough parenting plan.
Mm-hmm. Right. So interesting. We had a question the other day in the Facebook group about a parenting plan that this person agreed to that limited her ability to drink alcohol. So she agreed to abide by these incredibly restrictive covenants. And now she's looking to get married. And she's afraid that if she has a glass of champagne at her marriage 5 years later, that this is going to impact her, and she would be violating the court order. So it's very interesting also when we talk about a detailed parenting plan, what should be included and what shouldn't be. What are those things that you really want to stay away from? In my opinion, you want to stay away from anything like, you don't want to agree to celebrate joint birthdays together. You don't want to agree to do family dinners weekly. You don't want to agree to not drink alcohol. You don't want to agree to continue to attend the same church and go at the same time. You don't want to do that because the agreement you're entering into is going to live forever and you want to be allowed to change your mind. So what are some things that really do need to be in that parenting plan that are detailed, that need to be there?
Obviously, I'm going to start with the simple points. Obviously, as much detail about the schedule.
Mm-hmm.
What time is pickup? What time is drop off? What's the location? Sometimes people are like, oh, we'll just figure it out, and they put really loose terms, but the looser terms requires more communication. So if you want to be in constant communication with your ex, have very loose terms. But if you don't, then you need to have very specific terms. And keep in mind that the location of the exchange is really important, because you can set things up to where the exchange happens, for example, through the school or through daycare or through extracurriculars, and then you don't have to have a face-to-face. So the parent ending their parenting time would drop the child off at school or the activity, and then the parent starting their parenting time would pick them up. And, so you don't have any direct contact. And that could be really nice as you're figuring out this new relationship.
Yeah.
It can also be really nice for your kids
I
too, because,
agree.
there could be stress around those exchanges. So just some of those details, that's something that's a bit, pretty straightforward, but still not everybody does that. And I recommend the same thing for the holidays. Some people are just like, oh, you can have 4th of July. Well, what's the time frame? Is it an overnight? Is it the whole weekend? If it falls on a weekend, like really getting into the details on those issues. And then extracurriculars can be a big point of contention. Who's paying for it? How do you decide what extracurriculars to do? Is it just through the school? Is it a special club team? Especially the kids doing the club stuff. I mean, it's expensive. There's tons of travel. It takes up the weekends. That can bring up a lot of disputes if parents aren't on the same page.
Absolutely. Extracurriculars is one thing that I don't think is included enough in parenting plans, and then defining the terms, just like you're saying, like defining the terms of what the holiday means or what the other things mean. So we've got a lot of questions here waiting for us.
Okay.
Anything else on this topic before we transition to questions?
No, I think we covered a lot of ground there.
We did. All right, question 1, when can you go back to court to change things?
All right, so if you got divorced and you got a divorce decree or you established custody, the law wants you to wait a year to go back to change legal decision-making or parenting time. For child support, it's generally showing a 15% change. So I don't think there's that year-long prohibition on child support.
No, yeah, you're right. There's no,
It's just decision-making and parenting time.
right.
There are some exceptions. If there's an emergency situation, the child's in danger, you can petition earlier than a year, but you're going to have to show some very specific facts to show the court why you're coming back sooner than a year.
Definitely. All right. What type of evidence does the court need to not grant the other person visiting rights as an offender? I'm assuming they mean sex offender.
Okay, so the question is what type of evidence to deny that person parenting time?
Yes. So
obviously showing the conviction, and then possibly details about what led up to the conviction. What the word sexual offense is very broad. So what were the actual facts here that amounted to the criminal conduct? Because that's going to make a difference. Did it involve children? Did it involve the child at issue in front of the court? So that, and then anything showing that the person is not rehabilitated would be relevant, because that would be one defense that they could raise, is saying, oh, but I learned my lesson and I went through counseling and I'm normal now, whatever. And so having evidence to show, no, actually they're not rehabilitated, they're still engaging in harmful conduct.
Yeah, those are hard. Those are very, very hard. There is something you can request called a psychosexual evaluation that is used often in criminal court and often with juveniles to really assess risk. And I recommend that you consider that. Consider asking for that. You're probably going to have to be willing to pay for it. But if it looks like you're really, you're unsure if this person is a risk, it might be worth springing for the evaluation to find out.
And then also consider putting some responsibilities on the other side. So look, judge, it makes sense to have supervised parenting time, and the other side should pay for it because they're the one with the conviction. Not me. I shouldn't have to pay for this. They should. There's still safety concerns. No overnights. Parenting time only in a public place.
Oh yeah.
If you're coming in with a request for 0 parenting time, I would be making an alternative request for very minimal restricted parenting time as well, in the event the judge doesn't grant the no parenting time.
That's a great idea. What is the best option with a high conflict parent who's not involved in the children's activities when recitals and competitions are on their weekend, the court order is 50-50, we're still in court.
That's a tough one. I mean, each parent gets to do what they want to do essentially within the law during their parenting time. Is there a term in your parenting plan that you guys said, okay, look, we're going to agree to these recitals, and the parent with parenting time during the recitals required to take the kid? In other words, is this a violation of your order? You could enforce it in that case. I'm guessing it's not. That would be a pretty specific term. So you could, ask if you could make some proposals. Hey, look, I see you're not taking the kids to the recital. Do you mind if I take them next time? Is this an issue just where you don't want to do the driving and I can come back to you? Maybe see what the deal is. I know you're saying high conflict, so there may not be any communication. But yeah, you're in a tough place where if there's nothing in your plan to enforce and the other party has the right to do what they're doing during their time, you're kind of stuck. Billy, do you have any creative solutions?
Well, I really like what you're saying. So it says here you're still in court and there's 50-50 parenting time. So I don't know if you're in a modification or if you have a temporary order, but depending on your child's age, if their activities are very, very important to them and one parent refuses to take them, then what I would be trying to do right now is create evidence that you've done everything you can to try to accommodate this person's schedule and still get your child to the activities that are very important to them. The other thing I would consider doing is having the child interviewed so that the child can really express to the court how important these activities are to them. You may end up with not 50-50 if the high conflict parent refuses to make it happen, despite the fact that you've offered to take them, you've offered to give them makeup time, whatever it is. Like, make sure that you understand right now you're building a case. And I don't know what it is you're looking to get. Either you're looking to have the court force the other parent to take them to the things, which you might get an agreement, because the other option might be that this high conflict parent loses parenting time. So you really have to think strategically on this one, I think.
Yeah, definitely.
In a show cause hearing, what is the most appropriate way to ask family court services to investigate if the hearing is only for an emergency motion, but there's still a lot of other issues?
Okay, I need to hear that again.
In a show cause hearing, what is the most appropriate way to ask the family court services to investigate if the hearing is only for an emergency medical motion, but there are a lot of other issues?
So maybe of additional investigative resources in Maricopa County. We don't have anything like that in Yavapai, so I'm not sure who would investigate. But it sounds like, if you're wanting relief beyond what's on the table for this particular hearing, you could, file a motion that a hearing be set. It's hard to answer that question. I don't know, Billy, do you have any suggestions?
Well, I'm going to have to make a lot of guesses. So I am guessing that somebody filed an emergency petition regarding some medical issue. And that's the issue that's in front of the court. You have to file an underlying petition to modify when you file for an emergency motion. So your underlying petition to modify that couples your emergency motion should have all these other issues. And then if you're at the emergency hearing on the medical issue, I would maybe ask for a court-appointed advisor to be investigated, to be appointed to investigate all these other issues. But I'm making a ton of assumptions here with the question.
Yeah, we would definitely need a lot more information.
My spouse took all the furniture from our apartment while I was at work. In addition to that, she removed me from all the credit cards and emptied our bank account and moved it to a separate account. Would the bank account and the money from her paychecks be considered community property due to her commingling the community funds?
While you're married, any income is community income. So even though one spouse may be working to earn that money, if it's earned during the marriage, it's community money. It doesn't matter who earns it. So if the money was earned during the marriage, then it's community funds. I'm not sure if anybody's filed for divorce in this situation.
It doesn't say
pending divorce.
It doesn't say that.
Doesn't say. If there is a pending divorce that's been served, so both parties are aware of the divorce, then there's a court order called the preliminary injunction that orders both parties to maintain the status quo, in particular with community assets and debts, to not make changes. Now, there are exceptions to that. There's a case called Monaghan v. Strong, which interprets the preliminary injunction, but there's a potential violation here by her making all of these changes if the preliminary injunction applies in your case. One of the biggest questions for the court is, has she removed property to the extent that it's no longer within the reach of the court? Also, if she's doing certain things that are making it so that you're struggling financially and you can't pay certain community obligations, you could seek a temporary order to address these things.
Yeah, that was great information. Next question, what happens during a status conference for custody and a divorce?
Not much. A status conference is just where the parties and the judge touch base. Oftentimes, judges will set a status conference before they're going to set a trial date or contested hearing so that they can get everybody in one room and get everybody's calendars and figure out a date. If the court just issues a date without everybody's participation, often the court's dealing with motions to continue because of scheduling conflicts. So a lot of judges, especially really experienced judges, instead of just setting the hearing, they'll set a status conference and everybody can meet and get out their calendars and find a date that works for everybody. I would make sure it's a status conference and not a resolution management conference. They're similar, but they're different. And there's requirements as far as what you need to do 5 days prior to the resolution management conference that wouldn't apply necessarily for a status conference. So look back at the order setting the hearing and be clear as to what type of hearing it is.
That's a great point. And I like to file a status conference memo before a status conference if there's a lot going on and I want the court to address some things. But in terms of like what can they address, it's mostly procedural. So it's not substantive. They're not going to swear the parties in, although sometimes they do, but they're not usually swearing the parties in. So you could consider filing a status conference memo before the status conference, or writing one for yourself. That way you can stay focused and stay organized during that status conference. Next question says, what if the child wasn't born, but I'm pregnant and being abused by the child's father? How would you prove that? Only have hospital records of the abuse.
Well, remember that your testimony is evidence. So you testifying as to what happened is evidence. Now, if you can get any additional evidence to corroborate that, and that can be in the form of an additional witness. Let's say your mom, for example, was aware of the abuse. Your mom could testify as to what she observed. Or if you made a police report, if you took photographs of bruises, if you have any recordings, that could be some potential other evidence to corroborate your testimony. But even if you don't have the corroborating evidence, you still can testify under oath as to what happened, and the judge just gets to decide what way to give your testimony.
And you can also use those hospital records. There's nothing, I mean, the fact that you have hospital records of the abuse is pretty major. And I also think that there's literature connecting abuse while pregnant to child abuse. You may want to look at that, look for those scientific articles, bring them in. You can educate the court on that. And an infant is pretty darn helpless. So I really feel for you. How do I start the process to get full custody if my child's father is incarcerated?
So full custody, that would be an establishment, sounds like. And it's a matter of filing a petition to establish and then following through with serving him at the place where he's incarcerated. Mm-hmm. And then you'll see if he decides to participate or not. Oftentimes people who are incarcerated do participate because they don't have much going on. And so they'll,
you know where they are, they got time.
Yeah, they'll write letters to the court, they'll file stuff. So just because they're incarcerated doesn't necessarily mean that that it'll go to a default, that they won't participate. But obviously they're not in a position to exercise parenting time, decision making. So those are even if they do participate, you've got a strong case to get sole decision making and all the parenting time. There could be some sort of terms about communication between the children and the incarcerated parent. It's not required, but that could be something that comes up. And then child support. Generally, if someone's incarcerated, there's zero child support unless that person has some sort of independent financial resources. So if it's like a trust fund kid and, they're incarcerated, but they are getting, they have this huge trust fund and they have all this money, you could still get child support. But if it's somebody who's incarcerated and they don't have any trust fund and they're not working, then there's a zero child support order.
Yeah, and that was specifically added to the 2022 Arizona Child Support Guidelines. So previous to that, I think it was just kind of custom, and it was hit or miss. Like we had clients who the court refused to modify their child support, and they had to pay it out of their retirement funds. But under these newest guidelines, it's pretty specific that you can't expect somebody who's in jail to be working in prison to be working and making income and paying child support. Can you bring up sleepovers as a safety concern? Maybe include a restriction, sleepovers at other houses like friends. Okay, that's the question, but I think I'm going to reinterpret that as, is it appropriate to ask the court to prohibit parents from allowing their children to attend sleepovers? I think that's what she's asking.
Yeah, I've never had this issue come up. I would imagine, unless you have evidence that like the kid's doing drugs or something at this sleepover, unless you can show there's something really bad at this sleepover, I think the judge would say, hey, look, each parent gets to decide what, this is a personal care decision maybe, that each parent gets to decide during their parenting time. If you have sole legal decision making on personal care decisions, personal care decisions is not clearly defined. It's confusing as to what falls under that category, but maybe this does.
Yeah.
But if you have joint, I can see the judge just saying each parent gets to decide. But
Yeah.
I could see that being a co-parenting problem, if maybe the kid's starting to hang out with some racy other kids and you don't want them to, and who knows what's happening at these sleepovers.
Mm-hmm.
But, everybody's like, oh, let's just go to the court. And it's like, well, how about continuing to talk to your co-parent about this, in a non-attack way, expressing your concerns, and seeing if you guys can iron this issue out instead of just running to the court.
Yes. So this makes me think of other things like social media. Should we be putting in our parenting plans, when your child can have social media access? That's something that parents really disagree about, or other things like that. And what you may want to do is include a procedure within your parenting plan for dealing with issues that come up that you disagree about. And maybe that procedure is, we agree if somebody raises a concern, here's how we're going to handle that concern. That could help, because you don't know, right? You don't know what issues are going to come up with your children, but you want the opportunity to be heard and to work together. And so, maybe if your child sees a counselor, I don't know. Maybe if your child sees a counselor, you agree that both parents will meet with the counselor to discuss the issue and work together to come up with a plan that will work for both houses or something like that. So remember, if you can't come up with a substantive agreement, try to come up with a procedural agreement.
Mm-hmm.
Is it fairly easy to transfer custody from a parent to a grandparent?
No, it's not fairly easy. I mean, I guess if everybody's in agreement, you can draft the papers and get it signed off on. But the papers need to be done correctly.
Yeah, I mean, you could.
I don't see that as simple, but.
Yeah, you could do a temporary voluntary guardianship. Those happen through probate court. They're not through family court. I would consider those to be the simplest way, but everybody would have to agree. And those are revocable at any time. So depending on what's going on, maybe the parent's getting deployed and the other parent's in prison or something like that, then yeah, we're going to need to set that up for you. But this is really, really depends on what's going on.
Yeah, and then there's the third party rights statute. There's a couple of different ways to accomplish this.
Right.
And each way has different moving parts.
Yeah. Different pros and cons, different courts, different procedures. Totally agree. So this is the type of thing you want to talk to a lawyer about.
Yeah.
How long does a judge have to sign an order for alternative service?
Well, technically 60 days, right? You just have to rule on outstanding issues within 60 days. So that's probably the longest time. This is what I would imagine is happening. Of course, I don't know what the exact time frame is. But you file your motion and the clerk is going to automatically docket a response time, even though if you're asking for alternative service, that means the other side hasn't yet been served with the papers. So there is no need to docket a response time, but the clerk's just seen motion, response time needs to be docketed. So I've had this come up in cases before. And I'm like, man, why is this taking so long? And then I realized the court's like the judge hasn't even seen it yet because the clerk is waiting for the response time to run before the clerk brings it to the judge's attention. So I've remedied that at times by either contacting the judge's assistant or sometimes I'll file a motion, like not necessarily a motion, but a notice, notice of non-response time and explain. So I'd be curious how much time has passed. If it's close to where the response time is going to run, this will probably just remedy itself. Otherwise, if it's been a really long time, then yeah, I would want to bring it to the court's attention.
Definitely. I filed an emergency medical motion for sole medical decision-making of our disabled child due to a co-parent frustrating necessary medical care. It was denied, but there's a show cause hearing set. Tips? Any tips?
Okay, so it sounds like maybe she tried ex parte and that was denied, and now there's a hearing for both sides. Okay. Join our trial skills course. I mean,
join Win Without Law School and or buy the course on trial skills because you'll get how many hours of tips? Lots of hours of tips.
Yeah, I mean, that's a really long answer to do right now in this format, but preparation, you've got to prepare. What are you looking to prove? It looks like there's these medical issues. So when you say, I think it was dad isn't cooperating, like what does that mean? Where are the examples of him not cooperating? And this is something where one parent's perspective on non-cooperation, the judge can just see as a different point of view. The judge doesn't necessarily expect the parents to agree on every medical decision. So I'd really be curious, what are these medical decisions? And are dad's objections harming the child?
Yeah. And I'll tell you from my perspective, we as parents are going to be a lot more upset about our child not getting medical care than the courts. I've been there personally. It's incredibly frustrating. You can get through this, but it is going to take a lot of planning and a lot of preparation. And I would absolutely recommend, if you don't have a lawyer, that you check out Win Without Law School. I think it would be really good for your case because you have got to be strategic. What do I do if one of my children doesn't want to go to the other parent's house and refuses to go? There's no court orders at this time. We're in the middle of a divorce. The child's 12. Okay.
So the fact that there's no court orders, that's helpful. This is where I think this is a great opportunity to start talking to your co-parent and see if you can work together to seek to address this issue. Because your co-parent should care that the child doesn't want to come to their house. And so can you work together to resolve whatever issues going on? And I understand not all co-parents are good parents. So, you may be in a situation where that dialogue isn't easy to have, but if you are able to have that dialogue, that would be the starting point.
Yes. And also it might be good to go to a counselor. You're in the middle of a divorce. Family counseling can be incredibly helpful, and you can, I know you're like, I just got out of this marriage. I don't want to have to continue to pick up after my co-parent and be the bridge, but you kind of still do. If your co-parent is safe and your 12-year-old would be better off with a relationship, and you can help facilitate that by going and sitting with a family therapist with the three of you, or maybe just the other parent, the 12-year-old, that could be really good.
Yeah, and then talk to the 12-year-old. Why don't they want to go? You know, is it like a rules-based thing? You know, dad doesn't let me watch TV or whatever the hot thing is these days. Or is it, you know, dad yells at me and makes me feel bad? Like, what is the reason the kid doesn't want to go? Because that makes a big difference.
I totally agree. Can consistent overtime be taken into child support? Into
Yes.
consideration for child support?
Yes, that is the big question, is consistency, you know, historically present, what it looks like going into the future. And if it's a regular amount of overtime, yes. Now, the court, however, does say, look, we're not going to require a crazy work regimen just so that one parent can pay more child support.
Right.
So there is that catch to where if the overtime requires an extreme work regimen and the other side may be like, look, I'm not going to do that anymore, I'm going to do more parenting time, then that extra money may not be counted.
Yeah. I would say most of the time it's not counted. The exceptions that I see are firefighters, police officers, and nurses, where it's just part of the deal. It's never going to change. It's part of their regular schedule. It's not like they had been going above and beyond, because like Julie said, when you go through a divorce and you're taking on 50% of the responsibilities, you may have delegated your duties in terms of the financial obligations and the childcare obligations differently while you were married. But now you're two households that both have to balance the same financial obligations and childcare obligations, usually if you're doing 50-50. And so it doesn't make sense for somebody to continue working a bunch of overtime and not be with their kids so that they can pay the other parent more child support. If a parent has missed their parenting time, are they entitled to make up parenting time?
Before we get into that, I want to make one final point on child support.
Mm-hmm.
You know, sometimes parents get so caught up in, oh, overtime, or they're making more money. Like, run the actual calculations. What is the difference between the calculation with the overtime and the calculation without? Is it a $20 difference? Is it no difference? Or is it a big difference? Because you really need to know that information before you can decide whether or not it's worth pursuing this overtime issue or not. Because if you find that, oh, this is $10 more a month, like not even worth pursuing, you know, or do you have an attorney, or how much are you going to pay an attorney to pursue this extra amount? So really analyzing where you stand before going so gung-ho on some special, you know, extra amount of money in the child support calculator.
Mm-hmm. Yeah, I totally agree. And bonuses are treated differently than overtime. You know, bonuses are community property that's split. So that's just something to keep in mind too. We are almost out of time. I know you've got to go to Win Without Law School. Yes. Let's just do this one last question. If a parent missed their parenting time, are they entitled to make up time?
Generally, like if there's an agreement between the parents, you know, oh, we're going to swap and you can make up at this other time, generally then yes. But if someone needs a favor and the other side's giving a favor, it's not necessarily going to have to be, you know, not necessarily have to give them additional parenting time for that. So I think when the temporary change to your parenting plan is going to happen, you know, when somebody's asking for a favor, that's when you'll want to get really clear about what does this mean.
Yeah.
Or say, look, yeah, I'll do this for you, but you don't get makeup time for it.
Yeah. Or when you're asking, you know, it's, hey, would you mind trading me days? Or would you mind covering my days? Like, just be clear. But generally speaking, no, you're not entitled to make up time. So we're out of time for today. Make sure to check out winwithoutlawschool.com, register there so you can get more information about it. It's going really, really well. Thank you so much, Julie. And we'll be back here Thursday next week, same time.
Sounds good. Bye, Billy.